in jail too?
Yeah, these are all in jail, yes.
Okay. They show one on John Hannah. Is that what you show?
Mr. Hannah.
I'm sorry, Judge, I didn't hear you.
You have just one case on John Hannah today?
Yes, Judge. Yes, Judge, just one case.
We are on the record in 2024 CR 420, State of Kansas versus John Raymond Hannah. Please announce appearances.
Darren Riggy on behalf of the state.
Your Honor, Darren Patterson, appear on behalf of John Hannah. Mr. Hannah does appear via Zoom audio-visual from the Butler County Jail. Judge, this is a case where I am requesting the court to allow me to withdraw. I would just tell the court that communication has broken down to the point where counsel and client are not able to discuss the case any further, and would ask substitute counsel be appointed, or Mr. Hannah may hire counsel. I don't know.
Mr. Hannah, are you able to hire counsel?
I'll have to look into it, but I'm pretty sure I can figure something out.
Well, if you can hire an attorney, you should hire your own attorney. But you apparently told me or someone else that you couldn't afford an attorney early on, and you received court appointed.
No, I was saying that I have been in court. I've been pretty much in a situation where I was supposedly incarcerated, to where I haven't been able to contact my family members. What I explained. That's how I explained that. I don't like contacting my family members from facilities like this. I had problems stealing my mail and identity theft, so I really don't condone talking to my family member and giving out addresses in a situation like this with these people who don't have what they call a 922E or a 912E jurisdiction. So we can continue on if you want to try to. I just jurisdiction right now.
Well, what in the world is a 912E jurisdiction?
I'm the judge. You're supposed to figure it out. I'm telling you for.
I can't figure out something that doesn't exist.
It does exist, but
welcome to a courtroom where fantasy meets reality and confidence collides with the law. Today, we're diving into two sovereign citizen encounters that spiral spectacularly as soon as they step before the bench. First up, John Hannah, a man whose faith in obscure legal codes and imagined statutes is about to be tested against real authority. You'll see how someone can quote rules that don't exist, argue with a judge over imaginary numbers, and somehow convince themselves they're untouchable until the law proves otherwise. Later, we'll move to Ohio, where another individual tries representing himself and quickly learns that boldness does not equal competence. Stick around, because what seems like overconfidence is about to meet the harsh, unyielding reality of the courtroom. Trust me, you won't want to blink. Every second here is pure, jaw-dropping.
For me, and this dude is over here like supposed to be the. And then the other thing, dude told me that the court that he said it was going to be 3 days from now. He didn't say it was going to be today.
Who told you that?
He did. The attorney did.
All right. Mr. Regier, do you know what this... Tell me that number again. What is that number you're citing, sir, for jurisdiction?
922E.
922.
And you got a 912E, too.
And a 912.
Yeah, the corporate courts are illegal in the United States, pretty much.
Corporate courts are illegal?
Pretty much illegal in the United States, yeah. Pretty much.
Okay, that's...
On the Brady violation as well. Maryland versus Brady.
No Brady.
Yeah, Maryland versus Brady, yeah. And when we addressed this issue, you should have started with Maryland versus Brady. When you addressed me before anything, you're supposed to address me with Maryland versus Brady.
All right, stop it right now. I'm not going to keep taking your abuse.
Okay, I'm not going to take abuse. I don't want to lock those handcuffs on.
All right, you're going to stop it. You're going to sit him down, and you're going to show respect for the court. You have
it's my house.
Stop it right now.
My house. I built it, whatever. I built it. I'll pay down this bill.
You will stop it right now. I understand we have a screen between us.
Yeah, okay. I know we have a screen between us. I don't even know if you're in the courtroom, for real. Let's do a video.
Well, I think I understand why Mr. Patterson, a very experienced, very competent, qualified attorney, can't work
I got
with
one. I got a couple of them too.
Well, if you got them and you can afford them, there's no reason the taxpayers ought to be paying for your attorney.
I pay. What do you mean? I'm the taxpayer. They pay for my attorney. Point blank. Quit telling my intelligence, please.
Well, I'd order them to take you into custody, but you're already there.
I know I'm in custody, and you went up on my bond in custody. How do you do that? Oh, that's what Department of Justice right there. Thank you. Are there any more things to issue, Mr. Jay? What's the prosecutor's
You
name?
address me. You're stop it. Mr. Patterson, you are most definitely excused from this case for the reasons cited. You may journalize the dismissal.
Yes, Judge.
And I don't see any need to point anyone else because the defendant's telling me he can afford an attorney. You just need, what do you need to hire your attorney?
It's wild. John Hanna starts citing a 912E jurisdiction, a rule that exists only in his imagination. The judge's reaction says it all. Confidence alone doesn't create law. Notice how he tries to force the court to validate his fantasy statute, insisting that the judge look it up. The drama escalates as he conflates federal rules, Maryland versus Brady, and personal theories. This is a textbook example of what happens when someone believes sheer assertiveness can override procedural reality. It's entertaining, sure, but also a cautionary tale. The courtroom isn't a place for invented rules, and the judge is methodically dismantling Hanna's narrative, step by step, leaving no room for fiction to
reference to when he says 922E jurisdiction and 912E jurisdiction.
Wrote that down backwards.
Judge, I think those are pursuant to federal rules of procedure.
Well, we're not in federal court, so I don't keep myself.
But you have to go by my constitutional rights for a due process. For to be a corporate court, it could because you're financed by federal money. This is not financed by the people here in this county. It's found that you get government grants to run this place from the feds.
Where in the world did you hear that?
It's the truth.
Where'd you hear it?
I don't matter what I heard because I do my own research. I'm not answering that question. I would plead the fifth on that question.
Well, I don't know what he's talking about.
Exactly.
It's a federal rule, but this is not.
So we can bring up the competency of the court right now. We'll have to turn of justice on that. Do we need any issues, Mr. Prosecutor? The Department of Justice gonna be emailing you pretty soon.
Sir, let me explain something to you. You are in the district court, 13th Judicial District.
For misdemeanor accusation.
State of Kansas. This is not federal court.
So it says federal court.
The rules that apply are the Kansas statutes annotated. Yes, the Constitution applies, but you're not citing Constitution. You're citing apparently federal rules of evidence that apply in federal courts, not in Kansas.
No, that doesn't apply in federal court. It applies to a state because it goes with Maryland versus Brady.
Where did you get your law degree?
You don't have to have a law degree. Doesn't matter about that because I've been educated by the best attorneys in the United States. One of them is I happen to be real close to one of their daughters. A few of them.
As John Hanna refuses a court-appointed attorney, questioning their competency and claiming he can handle his own representation. This moment perfectly illustrates the tension between ego and reality. The judge doesn't flinch. He calmly reminds Hanna that his decisions have consequences and that time in jail isn't going anywhere. The courtroom on.
Right.
Yeah, I said I will figure it out is what I said.
All right, so you'll figure it out. You don't want the court to address another court appointed, right?
Pretty much not. Not with that competency level.
Not a court appointed attorney. So let's have the notes reflect. He does not want a court appointed attorney. He questions the competency level.
I'm going to go after the prosecutor now.
You want to go? You said you want to go
against prosecuting. Thank you. Say put that on the record because Terry Clark never forgot on paper. Thank you, Mr. Prosecutor.
So what did you say? You want to go after the prosecutor?
No, I said we will holler at the Department of Justice. We'll talk to him. Go after his accusation is what I said. Confirming his accusation with the Department of Justice. That's what I said. Thank you. Is there anything else I can get back to where I was legally incarcerated at?
Deputy, do you think the But does he normally behave competently? I'm wondering if I need to do a competency evaluation. Anyone want to be heard on that?
I've already had one.
In this case, you have?
No, I have one on my federal case. I felt competent because everything I stated with it, it's already backed by law.
Well, I am going to, on my own motion, order that there be a competency evaluation. That can be done in the county jail because I'm not sure you're tracking, Mr. Hanna.
Good for you. I don't care if you think that or not because I can decline it. I can decline that. And if I'm found incompetent, that means you can't do what? You can't put me in a court of law. So you just made another mistake.
Well, if you're found to be incompetent, you will go to a state security hospital.
No, I'm on it. You can't legally commit me to a hospital.
Yeah, I can.
No, you can't.
There, yes.
No, you can't. That just goes to show you try to commit me to it.
This is where the tension reaches a new level. The judge, seeing repeated chaos, orders a competency evaluation. John immediately fights back, claiming the court can't legally commit him, betting on confusion and legal loopholes. But the commentary here is crucial. His approach isn't ignorance, it's deliberate overconfidence. The court calmly explains consequences, highlighting that pretending to be unhinged in a forensic facility never works in your favor. This sequence showcases the dramatic irony. The more John argues, the more he confirms the judge's concerns. For viewers, it's both a lesson in legal realities and a suspenseful moment. Will overconfidence carry him through? Or is this the moment the law finally lands its decision?
So they have to do illegal commits, take people's property, identity theft. Yes.
And we need to do a competency evaluation. We will set this over. When's my next available jury trial date, Jen?
February 23rd for the pretrial, February 25th and 26th for the jury trial.
You said 26, and did you say 25 and 26?
That's correct, Your Honor.
Okay. All right. So the defendant is ordered to be here February 23rd for pretrial and February 25th and 26th in person for a jury trial. And then when I get the motion on file for competency, then we'll set the competency hearing before then, of course. I see you have had a U.S. Marshal hold on federal charges. That was back in April of last year. I see there was a previous failure to appear.
I was in Butner on an evaluation because I had to get rid of the last attorney I had. His name he was going under a fake name. His name was Kurt Burrows, and his name was Beemanhauer. So I had to remove from my case because he wasn't even who he said he was.
Well, I don't know.
Party mistake. Yes, I had conflict of interest. Yeah, I've had to remove from the case.
Well, I don't know either of those names. That must be on your felony charges.
Yeah, felon possession firearm, which I got a settlement on. That I got a settlement on when I was in federal prison for. Got a settlement for it. I've been illegally detained. It's in the law book.
And I see your first appearance, 9/6 of 24th. You were found. The court at that time, I think that might have been Judge Satterfield, I'm not sure, found you very combative and challenging jurisdiction even then. Oh, it was Judge Sanders. That was retired former Chief Judge Sanders. Okay, former Chief Judge Sanders. All right. Well, I think everything is resolved. Anything else, Mr. Regier or Mr. Patterson, we need to address on this matter?
Your Honor, more of a point of clarification. If the court is ordering a competency evaluation, the state will be requesting clarification as to who has prepared the appropriate journal entry.
If your staff has those forms available and wants to do that, that would be fine. If not, I'll have to do it myself.
Very good, Your Honor.
And Judge, I'm out of the case, of course, but I think Mr. Regier knows that it's supposed to be the local mental health department that does the initial evaluation.
Yes.
The state is well aware of that, Your Honor.
Thank you.
There's conflict of interest. He doesn't want interest.
Where's the conflict of interest, sir?
The prosecutor cannot give me he cannot be the one that gives me a competency hearing because he doesn't have my he's the one that accusing me of something. He's the one that brought up the charge. So he can't be the one in charge of my mental my competency hearing because it's a conflict of interest. It has to be somebody who has my interest.
Well, I don't have your
or somebody that's subjective to it. Objective point of view, it can't be him.
Okay, well, I'm the one that is ordering the competence evaluation. He just has the staff to do the paperwork, but I'm the one ordering it.
Okay. So, yeah, you shouldn't have said that, though. It's on record.
All right. Well, all right. That's the order. And Deputy, please, I'm remanding.
Now we see the courtroom shifting gears from chaos to procedure. The judge sets firm pretrial and jury dates, giving Hannah clear deadlines while reminding him that time is plentiful behind bars. The tension here is subtle but powerful. After months of theatrics, reality is imposing a strict schedule. It's a quiet kind of drama, showing that no amount of argument or eccentric belief can stop the wheels of justice. For viewers, this moment emphasizes the stakes. Hannah has a choice: adapt and work within the system, or continue clashing with a structure that won't bend to fate.
This is the matter of the State of Ohio versus Timothy Gordon II. It's case 25 CRB 1229. And you're Mr. Gordon, is that correct, sir?
I'm representing the estate. I'm the executor of the estate trust, and I'm here to settle the matter at hand.
You didn't answer my question.
I am not the all capital straw man. I am the living man.
Well, there's somebody sitting in this chair who's a living, breathing individual, correct?
Yes, sir. And I'm not a corporation like you guys are. I'm not.
Well,
together.
You may believe that, sir, and
no, that's the
I'm
truth.
not going to try to get you to believe other than what you believe.
Yeah.
But you, according to the record here, is you would be Timothy J. Gordon II,
the living man,
and we're here today on a bench trial in this matter. Are the parties ready to proceed?
The state is, Your Honor.
All right. And Mr. Gordon, you're not represented by counsel.
No, I do not consent to these hearings. I do not wish to contract.
I hear what you're saying, and
Sir,
I'm sitting up here prepared to hear any evidence regarding what occurred in this case.
I'm sorry.
I'm speaking.
Apologize.
Yeah. And we're going to go to a trial in this matter today. Whether you wish to be if you wish to be represented, you can be represented by counsel.
Nope.
Digging into Hannah's history reveals why this courtroom confrontation feels almost inevitable. Prior failures to appear, conflicts with attorneys, and even felony charges set the stage for today's spectacle. Each past incident compounds the tension, showing a pattern of defiance and legal missteps. The judge references previous appearances, highlighting the combative nature that's carried over time. This isn't just a one-off moment of overconfidence, it's a recurring theme. For the audience, these details build a richer story. We start connecting the dots between past behavior and present chaos, making the core.
State of Ohio will be presenting evidence through witnesses who are sworn, and those witnesses will take the witness stand here and tell the court whatever Ms. Yeager asks of those witnesses. At the conclusion of their testimony, you have the opportunity to ask questions regarding the testimony of the individual, and that's called cross-examination.
Yes, sir.
If you have questions, please make sure that they're relevant to the testimony and not something that's irrelevant. All right?
Yes, sir.
Once the state has presented its evidence, you may present whatever evidence you wish to present. You may testify on your own behalf, but you're not required to do so. However, if you choose to testify, you yourself will be sworn, and then you can tell the court what you want to tell the court. You can do it from right where you're seated. You don't have to come up to the witness
Can I ask
stand.
a question, sir?
Sure.
Is this a court of records?